We'll just go over a couple of housekeeping items. We do have a question and answer panel. You'll see that there is a place, if you have questions throughout the program, that you can type them into the Q&A section. We won't sort of interrupt Doug speaking to go over questions sort of in real time, but at the end, we will go through some of them and provide as many answers as we can. And if there's anything outstanding following the completion of the program, we'll follow up with you and get in touch and make sure that we get answers to you. There will also be a brief survey at the end of the presentation. So if you could just take a few minutes and get that filled out, we would really appreciate it. It gives us great feedback so that we can improve our presentations in the future. And so with that, I will turn it over to Doug, and we'll start learning about these very important and exciting elder law issues.
Thanks, Annalise. As you'll see, we'll only have from this point forward one attorney on the screen because there's not room for two attorney egos in one camera setting. Okay, so let's get started. I think it's important for us to kind of just set the stage for what we'll be talking about. We have a lot of our clients who come to us asking about what they can do to protect assets from the rising cost of nursing care. And so we do a lot of planning with our clients to go through these issues. And we know that they're increasingly important as individuals age and as the prospect of needing long-term care increases. So we feel like this is a timely issue and one that will be helpful to describe some of the planning opportunities that you have going forward for either yourself or for family members who you are assisting over the years. I've prepared quite a number of slides here, and they should be helpful for us to take a look through. It's important for you to understand that this is for your information. None of this is legal advice. We can't get into detail about your specific situations, and we're really just trying to guide you in a way to give you more information so that you're able to talk through these kinds of things with your family and loved ones and make some decision as to whether you want to get some more detailed legal advice from our office, which we would be more than happy to provide. You can come in to meet with us and go over these things whenever you feel comfortable. This should set the stage for you to have these kinds of discussions with the family and understand better, what things you can do to protect assets going forward. Before we get started about the specific planning issues, I think it's important for everyone to understand what they're confronting. Every year, Pennsylvania comes out with their statistics for the average cost of long-term care for the various nursing homes throughout the state. And you'll see on this slide, the cost is $482.50 per day in the average nursing home in the state of Pennsylvania. That comes out to $14,676 per month. Obviously, that is a huge cost and one that can be crippling for the total value of an estate. And that is really what is driving our clients to come to us to talk about this kind of planning and what they can do to protect and preserve their assets from this ever-rising long-term care cost. There are different scenarios that will play out. For either a individual who is married or is single. So one of the things that I'll go over with you are the different implications of the long-term care costs associated with a married couple needing that type of care or a single individual. So what happens to someone's assets if they move into a nursing home and have done no asset protection planning? The assets will be spent down quickly and at a clip of $14,000 to $18,000 per month, which comes out to $168,000 to $216,000 per year. This is a shocking and astounding monthly and annual cost for long-term care. And, if you do these numbers, an estate with $1 million could be gone in 5 years. So, we need to really think about doing this planning when we're reaching a point in time where we think that long-term care is in the horizon. Important conversation and a topic for understanding is the difference between Medicaid and Medicare. These are two topics that are really confused. Clients will come into us using the terms interchangeably, so I thought it'd be important to just give you a little bit of background on each of these different programs. Medicaid is the federally funded and state-run program that pays for the nursing home expenses of those who no longer have sufficient assets of their own. So if you've run out of money and you're in a nursing home care facility, Medicaid is the program that will start to pay for your care in that setting. Medicare, on the other hand, is a health insurance program, and that simply pays for doctor visits, hospital stays, rehab, and various medications. So if you have qualified for Medicare, that does not mean that your care in a long-term care facility will be paid for by the government. That will only pay for your regular hospital visits, doctor care. But if you need custodial care in a nursing home setting, you will have to privately pay and spend all of your own assets, basically until they're gone in a single person scenario. And once your assets have been completely expended, that's when Medicaid will kick in and start to pay the tab for your care in a nursing home. So now we have a situation where we have a married couple and one or the other spouse needs long-term care. It's important for you to understand what the spouse at home can retain. The spouse at home is referred to as the community spouse. That spouse at home can keep a car. They can keep their house subject to certain limitations. You'll see here noted that the amount of the value of the home that they can keep initially is $636,000. And that changes every year, but you can petition if you have a home that's worth more than that. But it is possible that they could deny you and you could potentially have to sell your home and purchase another one that has a value of $636,000 or less, and then spend the overage on your spouse's long-term care. In addition to the car and the house, the community spouse can keep their own IRAs. So no matter what the value of the community spouse's IRA, they can keep that. The spouse who has moved to the care facility, their IRA will be up for grabs and will be a part of the spending pot of assets. Spouse at home can also keep half of the remaining financial assets, or $137,400, whichever is less. So it's important that you understand that it's whichever is less, and the minimum amount that they can keep is $27,480. So in a scenario where maybe together they have a bank account that has, let's just say, $400,000 in it, those assets would have to be spent down until they reach the $137,400 level. And then once we've achieved that, Medicaid can be applied for. But in a scenario, let's say the husband and wife have $140,000 in their bank account, they would have to spend it down until it reached $70,000, which is 1/2 of that total. So it's, again, whichever is less. It's also important to highlight this is what they would have to reach if no planning is done. So really just trying to set out for you what it would look like if you just leave everything exactly the way it is and you reach this point in time where spouse needs nursing home care, you haven't done any planning, where would you be? And so this gives you a good frame of reference. In addition to these other assets the spouse at home can keep, the institutionalized spouse will also have the ability to retain a very small $2,400 amount. Moving on to the next slide, what can a single individual in a care facility keep before he or she can qualify for Medicaid? So obviously, there's the possibility of a single individual, perhaps a person whose spouse had already passed away. With them moving into a care facility, we have to look at what that individual can retain before they can qualify for Medicaid. So they can keep, again, one vehicle. They can also keep their house, which is a little bit misleading, because you'll see here that they have to first make a statement that they might return home, which is no problem. They certainly can make that statement. But even if they do retain the house, Pennsylvania has something that's called estate recovery. And estate recovery comes in after an individual has passed away, and they make a determination as to whether Medicaid has paid for that individual's care in a nursing home during their lifetime. And if they have, Pennsylvania will require that any assets that are in their estate be repaid to Pennsylvania in order to pay back the Medicaid expenditures. Only if there is an amount of money that exceeds the repayment would that money go to the beneficiaries. So in a case like this, it's quite possible that you could retain the house, spend a lot of money through Medicaid on the person's individual care in a nursing home. That individual passes away with the house still in their name. Now Pennsylvania comes in, they require the house to be sold, and they take those proceeds to repay the Medicaid expenditures. They can also retain a small $2,400 amount, and they get a paltry $45 a month out of their income to pay for incidentals. Okay, so we have a little bit more on this chart about the Medicaid qualification data. A lot of this is covering what we've already talked about. Okay, it also highlights one of the things that I did mention earlier, which is the IRA is owned by the institutionalized spouse. So the spouse who has moved to the nursing home will be countable. So it's just important for you to differentiate between the spouse who has moved to the care facility and the spouse who has stayed at home, and who can keep what and what assets will be preserved for that spouse at home. Okay, spousal impoverishment standards, again, going over the things that the spouse at home can retain. One of the things that I think we have not talked about that is important to highlight is the fourth one down there, maximum monthly maintenance needs allowance, which is $3,435 per month. This is the amount of the overall income that the spouse at home can retain. That's the maximum amount. So if you have Social Security payments, pension payments, whatever they total, the maximum portion of that the spouse at home can retain is the $3,435. Anything over that is attributable to the spouse who has moved to the care facility will have to be paid to the care facility before Medicaid pays the rest. Okay. Now, one thing to just clarify there, the spouse at home, the community spouse, if they happen to be the spouse who is receiving a greater portion of the overall income because maybe they have a higher pension or higher Social Security and pension combination, they will be able to keep their own income. But if that exceeds the $3,435 on a monthly basis, all of the spouse who has moved to the care facility's income will go to the care facility, and the spouse at home won't be able to keep any of it. Okay. So giving all that important data and information about the cost for long-term care kind of probably answers what we're going to go over here, But why would someone want to do plan to qualify for Medicaid sooner? So we saw what would happen if you do nothing, how long it would take for you to consistently spend all the assets down until Medicaid was qualified for. So we want to do a few different things when we're doing the Medicaid planning. We want to protect the spouse at home, this community spouse. We want to make sure that they have enough assets to preserve their standard of living for the balance of their lives. So you could have a spouse who lives at home for years after their spouse has moved to a nursing home facility. We don't want to leave them in a position where they can't stay in their home, they can't provide for themselves, where they become dependent on other family members. So there are things that we can do by planning ahead of time to protect and preserve the assets for the benefit of the spouse, the first spouse, at the time the first spouse moves to the care facility, and for the spouse who has retained the home and has stayed there. So we want to preserve the family home for the children. So driving force for a lot of our clients is protecting the family home and other financial assets for their children. Our clients have worked hard. They've amassed a nice nest egg. They've developed their own financial plan. They've grown their assets nicely, and they feel strongly that they don't want to see these assets gone by way of the nursing home. And they realize that with the rising cost of long-term care, this is exactly what can happen. And they want to take steps to protect and preserve the assets for the family so that they can see their kids and their grandkids enjoy those assets. So what kind of planning can be done now to protect and preserve the assets for your spouse and your children? So the planning that we do as part of the what we call advanced planning, meaning the ahead of time planning, is gifting. So the primary planning opportunity that we'll talk about today is gifting of assets. When you make gifts of assets, Medicaid has certain rules that will cause ineligibility as a result of those gifts. Presently, the law says that every time you make a substantial gift, that you would be ineligible for Medicaid for the 5 years that follow that substantial gift. So there's a point in time where you go to apply for Medicaid. And when you do, they'll have a question on that application, and it will say, during the last 5 years, have you made any gifts? And then you'll have to answer, yes, I've made substantial gifts, and here's what they were, and the amount that was gifted during that 5-year period. So our goal is to transfer assets now so that you can live your normal lives during the next 5 years, and 5 years and a day into the future, those assets will be protected. Okay, so you're gifting mindfully with an eye toward getting through a 5-year waiting period and then being able to qualify for Medicaid at some point after that, and having the assets that were transferred be protected as a result of your pre-planning. When we're making gifts, the main avenue for making those gifts is into what we call a Medicaid Asset Protection Trust. We use this planning for a number of reasons, which we'll highlight for you. A lot of this program will be intended to discuss the nuances of that Medicaid Asset Protection Trust, why it should be used in lieu of direct gifting and transfers to your children and loved ones, and why the gifts to the Medicaid Trust are a better way of doing the planning. So here we have, what is a Medicaid Asset Protection Trust and how is it managed? Importantly, the Medicaid Asset Protection Trust is an irrevocable trust. So there are a myriad number of different kinds of trusts. There are different umbrellas. The main umbrellas of trust planning will be irrevocable trust planning, and revocable trust planning. So for our purposes, when we're talking about doing a Medicaid asset protection trust, we are creating an irrevocable trust. And what that means for you is that when you create that trust, you as the grantor no longer have the ability to modify or change the terms of that trust. You're giving up the ownership and control of the assets, and you're putting someone else in charge. Okay, so threshold question for the planning process is, do you feel comfortable giving up that ownership and control irrevocably and putting someone else in charge to make sure that those assets are properly managed and distributed either during your lifetime or at the time you've passed away? The irrevocable trust provides a place to hold the gifted assets during your lifetime, which is important. It creates a protected environment. It allows you to name a trustee, which is a person who would be managing the assets. The grantor, the person creating the trust, cannot be the trustee, okay? So again, you're giving up ownership and control. You're putting someone else in charge. Okay, now you can pick the trustee, all right? So you can pick whatever child or loved one or person you feel would be best suited for that management role, which is a nice thing because you may love all of your children, love all of your family members, but they may not all be the best and most well suited for the job of trustee. Okay. We tailor these trusts to each family situation. So even though we have common goals, which is mainly to protect the assets from nursing care spending, each family has a different situation. They also have different assets they're transferring to the trust. So we will tailor the planning to each family situation to make sure that they are not only protecting the assets from the nursing care spending, but they aren't unwittingly opening the assets up to additional taxes, transfer fees, and also making those assets available to either divorces or creditors of the beneficiaries. So really important nuances to the planning that people don't even think about when they're initially considering doing this kind of thing. They're thinking, oh, well, I just want to make sure that my assets are protected from the nursing care spending. But really, you know, there are a lot of other things that go into the overall trust development that we go through with the clients and make sure that they understand. And by the end, you'll feel significantly more comfortable after we've had an opportunity to talk through these things, realizing that the assets transferred to the trust will have all of these additional protections. Okay. Importantly, as I mentioned, because this trust is irrevocable and because you no longer, as the grantor, have the control over those assets and you've given them away, that starts the 5-year ineligibility period. So the day that the assets are transferred to the trust, you can start that clock ticking on the 5-year waiting period, all right? So it's not when the trust is created, the day you sign the trust. It's the day that you actually physically change the ownership to the trust. So frequently, we'll meet with clients and we'll create these trusts, and we'll also help them to prepare the deed to their home to transfer ownership of the property to the trust. And that usually takes place that day. So they sign the trust, and minutes later, they'll sign the deed to transfer ownership of the house to the trust. But they'll still have to potentially go out to the banks, financial institutions to retitle those kinds of assets to the trust. So we always tell clients, create a little spreadsheet that lists the different kinds of assets they're transferring to the trust and put a date next to each one for the date that they've actually successfully transferred ownership to the trust. That way they can keep track, because the 5-year ineligibility period will be different for each of these different assets as they're transferred. And we'll talk about this a little bit more, but I think it's important really to highlight that a couple of times as we go through this. Okay. So who can act as the trustee of the Medicaid Asset Protection Trust? Okay. So again, you can name your most trusted or responsible child, friend, or loved one to manage the gifted assets in a centralized manner. So we want the Medicaid Asset Protection Trust to mimic as closely as possible the way that you would manage the assets during your lifetime if you had retained ownership of those assets. So we've found that psychologically creating the Medicaid trust and holding those assets in this centralized location for all of the family members to know that, hey, this is still mom or dad's or mom and dad's set of assets during their lifetime, even though technically from a legal perspective, they are not. And even though you have given up ownership control, we've put those assets in one place. We've put someone in charge who we think is going to manage them and more or less do what you would expect of them for the investment of the assets in stocks, bonds, mutual funds, real estate. They'll sell real estate when you want them to. They'll do all of the things that you would intend for them to do. Again, grantors and the grantor spouse cannot be trustees. We will have a disinterested distribution trustee in almost every case. So the purpose of having this second trustee, in addition to your child or loved one who's acting as a trustee, is not to keep the children from basically being able to access the assets that are in the trust. It's intended to help to significantly increase the protection of those assets that you've put into trust from the things that might happen in the trustees or other beneficiaries' personal lives. So what we don't want to have happen is for our clients to transfer assets out of their names and into a trust like this, only to then have something happen in one of their children's personal lives. Again, a divorce, a creditor, or a lawsuit, and have one of those things happening in the outside world, being able to bleed into the trust, and for those outside entities, divorcing spouse or a creditor, to be able to come knocking and say, hey, I want to get paid out of that trust that our client has created. So having this distribution trustee is basically thickening the wall of protection that is provided for the assets that are in the trust. By having a distribution trustee, we'll have the ability to basically say that these assets in the trust are not owned by the individual beneficiaries, that those beneficiaries can get distributions, but only after this distribution trustee says that it's okay to make the distribution. And so that further distances them from personal ownership and makes sure that those assets are protected. Now, we will build in some things that will probably make you feel a little bit more comfortable about having the distribution trustee, which would include the ability to have that distribution trustee removed and replaced periodically, either by the family trustee, so the loved one who's acting as the main trustee, or we can also appoint someone else that we refer to as a trust protector. And a trust protector is someone that we can give the power to remove and replace the distribution trustee if by chance. Now, we don't expect this to happen, but it's always possible. If they're not making good decisions, if they're not responsive, if they're saying no to distributions when they should be saying yes, we have an avenue to remove them and replace them, so we're not stuck with a person who's not doing a good job. So what kind of assets can you transfer into the Medicaid Asset Protection Trust? Almost everything that you own can go into the Medicaid Asset Protection Trust. So we can just go down this list just to give you a flavor for what can go in there. We can transfer real estate. So again, primary residence is most common. Occasionally we'll have clients who have a mountain home or a shore house that can also go into the irrevocable trust. Usually not a problem to make those transfers either. Can transfer stocks, bonds, mutual funds, small business interests, annuities, cash, and life insurance policies. So a couple of those that I just note, most of them are pretty obvious items. Annuities, as long as they're non-qualified annuities, so they just can't be an annuity investment within an IRA. Also note there that to the extent that you have gain that has accumulated within the annuity, so let's say, for example, you've made an initial contribution of $50,000 into the annuity and it's worth $100,000 because of growth. If you want to transfer that to an irrevocable trust, it does accelerate the point at which you have to pay the income tax on the $50,000 gain in that example, so that you have to pay the tax at the time you transfer the annuity into the irrevocable trust. So you have a little bit of a penalty there. That being said, somebody someday will have to pay the income tax on that growth. So all you're doing is accelerating the point in time where you have to pay the tax. You're not creating a tax where it would otherwise not have ever existed. Life insurance policies, it's an important one because people overlook this all the time. You could have, small to medium life insurance policies that have increased cash value over the years. The cash value is considered a spendable asset for nursing care. So when you're calculating what is the value of my estate and my assets and what needs to be spent on my care before I can qualify for Medicaid, life insurance policies are one that you need to examine and see what the cash value is. And you might have to transfer the ownership of that life insurance policy over to the irrevocable trust because the cash value would have to come out and you'd have to spend all of that on the nursing home care before you could qualify for Medicaid. We've had people come to us upset by that in the past, and we've had to walk through why that's the case and what we can do under the circumstances. What can't be transferred to the Medicaid trust? Two main items that come up. IRA is the absolute number one that we see frequently. And then there's the 401k, which is less common because at the point people are thinking of transferring assets into the Medicaid Asset Protection Trust, they maybe have stopped working. So the 401k probably has been rolled over into an IRA, but there are occasions where people still have a 401k, or you could also have, some of our clients are working later in life and they still have a 401k. But regardless, those retirement assets cannot be transferred into a Medicaid Asset Protection Trust. And if you are looking to protect those assets from nursing care spending, the only way to do it would be to pull the money out of the IRA or 401k, more likely from the IRA, and pay the income tax and then put the after tax money into the irrevocable trust. I'm not suggesting to do that. I'm just explaining that's what would have to have you do. We'd have to have you do if you wanted to create protection for those kinds of assets. But we always tell clients, you've got to review that kind of thing very closely with your financial advisor and your accountant to understand what the implications of doing that would be. Because we also, as we're doing this planning, we'll keep a close eye on making sure that the client's best interests are taken care of. And we don't want you to do something that will jeopardize your personal well-being going forward just to protect assets for your children and loved ones. We understand the overarching goal and desire to protect and provide for the kids, but at the same time, we don't want to do something that's hasty and detrimental for you and might leave you in a lesser position. So what are the benefits of this Medicaid Asset Protection Trust? Key component is that after 5 years, each gift to the Medicaid Trust will be 100% protected from the nursing care spending. So that's our primary goal. We want these assets to be put into a place where they don't have to be spent on your nursing home care. And that's exactly what will happen 5 years and a day after those assets are transferred into the trust. The Medicaid Asset Protection Trust will provide asset protection for the gifted assets during the grantor's lifetime. So the assets that go into the trust will be protected from the nursing care spending after 5 years. But interestingly, they're also protected from other things that could happen in the grantor's personal life during that period of time and really for the rest of their lives. So if they happen to have something happen like a car accident or some sort of legal action against them stemming from that car accident or even some other issue in their personal lives, none of those things can bleed over into the trust as well. So, it's probably not a likely scenario, but as individuals age, there is sometimes a worry about the liability risks associated with driving. And, we've had clients in the past get into car accidents and we've had them actually be sued. And if it goes through the limits of your car insurance, they could go after your personal assets. So the assets in the trust will be protected from those kinds of things as well. Third one down the row there, assets will be protected from the divorcing spouse, creditors, and lawsuits impacting the children. So we've talked about this earlier, but I think it's important again to talk about some of these things multiple times throughout our conversation. We're putting these assets in an irrevocable trust to create protection from the nursing care spending, but we also are making sure that those assets are safe and they can't be lost as a result of something that happens in the personal life of the beneficiaries. So we talked about who would be the trustee, and that might be one or more of the trusted family members, but you could have 4, 5, 6, 7 or more children or beneficiaries of these trusts. And some of them may live, a different lifestyle. They might also have things that just happen in their personal lives that are outside of their control. Divorce, as an example, might not be something that is a direct result of things that they've done, but it could happen. They might be involved in a high-risk business endeavor, and there could be a prospect of them being sued personally during their lifetime. And we don't want what's going on in their personal life to be able to reach the assets that are in the trust. So we developed the trust to have this dual asset protection component so that the assets in the trust are safe and protected in case they're ever needed for our client, the grantor, at some point in the future. The assets in the irrevocable trust will also protect against beneficiary misspending. And what I mean by that is we've commonly had clients ask us, why don't I just transfer ownership of these assets to my 5 kids? I'll just put 5 kids on the deed. I'll put my $500,000, $100,000 to each of my 5 children. And why do I even need to bother with the trust? Well, a lot of the things we've already talked about, exposure to divorce, creditors, and lawsuits being one of them, but also the spending habits of these beneficiaries will be very different. If we have a situation like that, invariably, you would have one or more of those children spend the money that was given to them with the expectation that, oh, mom or dad won't need that money again. And if they do, I'll make up for it. I'll put money back in. What we've found in those rare instances where clients have kind of come later saying, I did this and I shouldn't have, now what can I do? We find that there will be, again, a few of the kids who very responsibly put the money away safely and securely. Now, mom or dad needs care or has other needs, and they need to recontribute some of those dollars. Well, who's going to have the money that's going to go back to mom and dad? The ones that saved the money and kept it protected for them. Meanwhile, these other beneficiaries have spent all of the money and they can't recontribute. So there's a consideration of equity there. We want to make sure that that money is safe and secure in one pot. No one feels like it's theirs. No one feels like they can spend it for their own personal needs. It's going to stay there till the mom or dad or the grantor has passed away, and we can feel secure that everybody is going to be treated properly and equally as a result of that. Last on this list, on this slide anyway, we'll be talking about a few more benefits going on to the next slides, but this one says avoid probate. So any assets that you've transferred into the irrevocable trust will be protected from probate. Probate is the court administrative process that an executor typically would have to go through if there are assets in the decedent's name alone and which don't have any kind of beneficiary designation on them. So anything that you've already given up ownership to and put into the irrevocable trust will be completely protected from probate, and those assets can transfer more quickly and easily and less expensively to the beneficiaries. Now, just one aside there, most clients don't transfer all of their assets to the irrevocable trust. So the assets that have gone to the irrevocable trust will definitively avoid probate. Other assets they've retained, maybe a bank account, maybe a small stock account, maybe their own IRA, those assets would potentially transfer through probate. So the other part of what we do through this planning process is to work with the client to understand what they need to do with the assets that they retain in their name and that they have not transferred into the trust, and what they need to do to make sure that those assets also avoid probate. So when we're talking about doing this planning, it's not just let's turn all these assets over into the irrevocable trust. It's really a holistic approach of what are all of the different things that we can address to make the overall planning process better and everything transfer more quickly, more easily, and less expensively for the beneficiaries. Another big potential benefit is avoiding Pennsylvania inheritance tax. So assets that are transferred into the Medicaid Asset Protection Trust can avoid Pennsylvania inheritance tax. So there are certain situations where avoiding the inheritance tax is not desirable, and I'll explain that a little bit. It's a little bit of a complex component of the planning, but I will go through that. But generally speaking, if you transfer ownership of assets, and as long as they have been transferred out of your name for at least 1 year prior to you passing away, those assets will avoid Pennsylvania's inheritance tax. Pennsylvania's inheritance tax starts at $1 of your estate, and the tax rate is dependent on who you're leaving assets to. So you'll see a little chart here to give you an idea of what those tax rates are for the different beneficiaries. Most commonly, transfers to spouse, 0%, transfers to children and grandchildren, 4.5%. Less common, transfers to the parents, 4.5%, siblings, 12%, nieces, nephews, 15%, aunts and uncles, 15%, and friends, 15%. Charities, also 0%. Okay, so you can see that we have a pretty significant potential inheritance savings on top of getting this asset protection component and the Medicaid qualification benefits. So this just gives you some more definitive round numbers for what kind of protection you could potentially achieve. And we've used this 4.5% tax rate because that's, again, the most common scenario. But if you happen to be doing this planning for nieces and nephews, as an example, or friends, which we do have happen for a number of our clients, the savings could be exponentially more. But if we have this planning done for parents who are looking to preserve assets for their children, this is the kind of savings that we're looking at For a $500,000 transfer to the trust, that's $22,500 of tax savings. For $1 million that's transferred into the trust, we have a $45,000 savings. So those kinds of inheritance tax savings are going to be significantly greater than even the cost of doing the planning. So for a lot of our clients, they say, well, look, I'm doing this planning. I might never need nursing home care. Is it really worth it to spend the money to get this planning done? And when we highlight this component of the potential benefits, a lot of them say, well, look, even if I never need nursing home care, and if these assets didn't need to be protected from that long-term care cost, I know that if I live for a year from this point in time, when I transfer the assets to the trust, I'm going to achieve at least this kind of savings. Plus, I'm going to avoid probate for my beneficiaries. Those two things alone will more than pay for the cost of the planning. And then for those clients where the nursing care needs end up coming to fruition, that's obviously the home run on the planning side. And that's really what we're doing the planning for as the number one cause. But these things can sort of make you feel like, I know I'm going to get my money's worth no matter what happens. Common question, have this happen all the time when clients come in, and they're trying to overcome the initial concern or fear of transferring ownership of assets to the irrevocable trust. They say to me, well, what if I transfer my house to the trust and my trustee goes rogue and my child decides I'm going to kick mom or dad out of the house and I'm going to sell the house because I don't think they should live there anymore. So that's a natural worry and concern when you're giving up ownership of an important asset like your primary residence. We understand that, and we have developed ways to help to protect against something like that happen. We've yet to have to really enforce or employ these kinds of things as a measure to keep our client in the house where their family has really been trying to move them out unwillingly. So thankfully for that, it doesn't mean that we shouldn't do planning to protect against it, because we know that these things are possibilities, even if they are not probabilities. So there are two things that we'll use to create that kind of protection. One is a life estate agreement. So when our client transfers ownership of their primary residence or other piece of real estate into the irrevocable trust, we can reserve something through a separate agreement, which is called a life estate. And that is the ability to reside, use, and enjoy the particular piece of property during the balance of their lifetime. That is a legally enforceable contract that is signed by the client grantor and the trustee of the trust. So that would help to preserve their right to use and enjoy the piece of real estate for the balance of their lifetime. Second one is a long-term lease. And so the long-term lease gives the ability to reside in the property, but the person who is reserving that right to reside there will have to pay rent to the trust on a monthly or annual basis. Now, it might sound like the life estate agreement is cleaner and clearer and kind of mimics what your initial desire would be. And you might think, well, why would I want to have to pay rent back to the trust? This is here in part to kind of give you an idea that you can be protected and safe and retain the use and enjoyment of the home or other piece of real estate, but also to highlight one of the important tax considerations that we work through with our clients. When you use a life estate agreement, the life estate also triggers the inclusion of the real estate in the decedent's estate when they pass away for estate tax purposes. So let's say, for example, we have a single individual who transfers the house into the trust and they reserve a life estate. Years later, they pass away. If that happens and they have the life estate, that means that house is taxable in their estate. They would have to, they, meaning the kids, through the estate would have to pay an inheritance tax in Pennsylvania. And you say to yourself, well, why would I potentially want to do that? The reason for doing that, and the reason why we would maybe want to have to pay the inheritance tax, is in order to get an even greater tax savings. And that tax savings would be resulting from what we call the step up in basis for capital gains tax purposes. So we have this happen all the time for our clients because many of our elderly clients purchased their home a long time ago for a very small amount of money compared to today's dollars. So as an example, let's say we have a house purchase for $50,000 locally to where my office is right here, which is in Phoenixville. Again, not uncommon because we have clients who made these purchases 40 plus years ago. So they have purchased the house for $50,000 and it's worth $600,000 today. So we have $550,000 of gain, not taking into account potentially some other improvements that have been made over the years. So if you transfer the house into that trust and you don't use the life estate agreement, what that means is when your children sell the house after you pass away, and because there was no step up in basis, they'd have to pay capital gains tax on the growth from the $50,000 all the way up to the $600,000. And that would be a 15 to 20% tax on that capital gains tax payment, all right? Conversely, if we use the life estate agreement, we cause the property to be taxable in the estate, we pay the 4.5% tax, but we get the full step up. So the basis goes from the $50,000 purchase price all the way up to the $600,000 value as of the date of death. So now when the kids sell the house, they don't pay any capital gains tax on the sale. They pay 4.5%, but they don't pay the 15 or 20% tax. So that's an example of a powerful tax savings that you get with the proper planning. And we really have to look closely at the kinds of assets that are transferring and whether we want to trigger the step up in basis or not. Conversely, in a case where we have maybe an elderly client who has recently moved, which again happens with some frequency, they've downsized and they've moved into a condo for easier property management and living. And let's say that condo is worth $400,000 and they just bought it. So their basis is the $400,000. So now we don't have any gain. We don't need the step up in basis. So for that situation, we use a lease because a lease creates a business relationship. So now they just pay a rental amount every month to the trust. Their child loved one, who's the trustee, manages that amount that's been paid to the trust as rent. And what happens is they'll use the rental payment to pay for the taxes, the upkeep, the maintenance of the property. So it's really just shuffling who gets the money and where the money is spent from to take care of the ordinary expenses. But the importance there and then is because we had a lease and not a life estate agreement, when the individual passes away, that $400,000 condo is not includable in their estate. And therefore, there is no 4.5% Pennsylvania inheritance tax that will apply. So there's a real nuance on this tax issue. Again, something that's a little bit below the surface that we make sure that you're protected on and that we'll be cognizant of every time we do planning for our clients. And we don't lose focus of these kinds of things when we're thinking about protecting the assets from the nursing home spending. We don't want you to do that kind of planning only to then realize, well, you've gotten yourself into another jam or created an extra expense or tax for your children unwittingly. A big question that comes in from our clients as we're doing this planning. Well, what if I do this planning and suddenly I need nursing home care before the 5 years is over? Is everything lost? Does that mean that my planning is a complete waste and I have lost all of the benefits? So the important answer to that is all is not lost. All that means is that you or the family will have to privately pay for whatever the remaining balance of that 5-year ineligibility period is. So a good example of that is right here on this slide. If we look at this scenario, we have a client who made a gift of $500,000 to the Medicaid Asset Protection Trust on January 1 of 2023. They moved to a care facility on January 1 of 2027. So they had relatively good health for 4 years. The result of that is they have 1 year left on the 5-year Medicaid ineligibility period. So they have to privately pay for 1 year, and then they will qualify for Medicaid on January 1, 2028. Okay. So as a result of the planning, they had only 1 year of Medicaid, on nursing home spending, and they're able to qualify after that 1 year for Medicaid. And so of that $500,000 that was transferred into the trust, probably about $400,000 of it would be completely protected. So you haven't gotten through the 5 years, you haven't maybe protected the full $500,000, but you've still protected the vast majority, and it's still made that planning well worth it. Another important question that comes up: can the grantor get money back once it's gifted to the trust? So the answer to that is yes, but not directly. Okay. So what has to be written into the document is the ability for the trustee to make distributions out to one or more of the grantor's children or other beneficiaries. So what we're doing is we're creating an escape hatch, a way for us to distribute assets out of the trust. Now, we can't put anything into the document that says that the trust can make a distribution directly to the grantor or the grantor's spouse. In fact, we will have a direct prohibition against that. So it will say, under no circumstances may the trustee make a distribution to the grantor or the grantor's spouse. However, because we have created the avenue for distribution to one or more of the children or beneficiaries, what typically will happen is the trustee will make a distribution to one of the kids. One of the kids will then deposit that money into their personal checking account or savings account. And then they'll turn around and they'll pay for something for mom or dad directly out of their personal assets. So once the assets are distributed from the trust to the individual beneficiary, the beneficiary can do whatever they want with that money, including spend it for their parents. So we've created a two-step mechanism for getting the money back to mom and dad: distribute from the trust to the child, from the child back to mom or dad. The only thing that you have to be considerate of and comfortable with is the fact that when that distribution goes out to the child beneficiary, that they will in fact recontribute it to their mom or dad. And of course, we hope that that's the case. And the trust will be written in a way that will also give the trustee the discretion to give to any one or more of the kids. They do not have to give to all of them. So it could be that you have maybe one of the children who's more likely to take that money and recontribute it to the parent, grantor, And so, of course, we would make the distribution to that particular child and not spread it out across multiple beneficiaries and take any chances. So, important consideration is really who is going to be thinking about doing this kind of planning. When we talk about doing the planning with our clients as they come in, I'd say the most typical client profile would be a single person or married couple who are in the late 60s to the late 80s. So we don't want people doing this too early in life or even maybe too late in life where it doesn't make sense any longer. But too early in life, we recognize and respect the fact that you want to hold on to your own assets. You want to manage them. You want to use them. You want to enjoy them. You don't want anybody else kind of involved in interfering with your personal lives. So, our goal really is to just let you know the things that you can do. And then you'll tell us when you're ready and when you want to move forward with this kind of planning. But this is when you should really start to think about it in your late 60s. The idea behind this planning is getting through 5 years of ineligibility. So we don't want to wait too long because the percentage chance and likelihood of getting through the 5 years of ineligibility for Medicaid obviously decrease as you get older. So the sooner you do it, the greater the likelihood that you will be successful in the planning that we do. That doesn't mean you've got to run out and do it in your late 60s. It's just that that's when you start to think about it. And we do have clients who start to move and they start to do those kinds of, gifting and planning structures in their late 60s and early 70s. And their comments to a man and woman would be, we just feel more comfortable giving up this ownership and control now when we feel healthy and vibrant and less likely to need nursing home care. And we feel completely comfortable with one or more of our children being in charge. So, that's their answer to us. And by the way, I have plenty of clients that I talk to that are reluctant and they hold off on the planning, maybe till a little bit later in life. And then, of course, we have clients who are just coming to us for the first time and they're in their late 70s, early 80s, and even into their late 80s, and they're doing that planning at that time as well. From an asset perspective, sorry, just go back one. People ask this as well. There's no perfect answer to this, as far as when you should consider this as it relates to your total personal wealth. I've just found that it's more likely and imperative on the planning side for clients who have 2.5 million or less. And that's sort of an arbitrary number. And it could be a little bit, on either side where you're going in either direction. But if you really just think about, again, what the cost for this care at $160,000 to $200,000 a year, what that can do to an estate, like your estate and the investment of those assets and the income that you're bringing in from Social Security and pension, all that kind of stuff, just won't be able to keep up with that expense at those figures with an estate of 2.5 million or under. So those are the people whose assets will be eroded most quickly because of that nursing care cost. So, God forbid, if you ever have a situation where you have a husband and wife who need this care simultaneously, well, obviously you're double those costs. So you're now at $350,000 to $400,000 a year on that cost. That's exorbitant by any measure. And, you could potentially even move this $2.5 million number up for situations like that. I have, unfortunately, a case that I'm working on now with an elderly couple who actually do not have children. And they've asked me to help out to act as power of attorney. But now both of them have moved into a care facility of their choosing. And they are each spending $18,000 a month. So every single month, I am writing a check to this care facility for $36,000 for the two of them. They're going to be out of their money very quickly, and they will be qualifying for a combination of the benevolent fund in this care facility and Medicaid. But it's just like probably I don't like the fact that they're having to spend this. The only thing that I like about the situation is the fact that I can go and confidently tell other clients, like, this is a real possibility because I am seeing it happen and I am witnessing the devastation to their financial circumstance. Now, just so happens that they don't have children. They don't have any beneficiaries that they felt particularly strongly should receive the benefits of the inheritance. So they were okay with the idea of having their assets spent down. So that they're unique in that regard as well. But the financial issue of $36,000 on a monthly basis really tells you what can happen to an estate. So when we're doing this planning for clients, I think it's important for everyone to understand what the upfront costs will be for them. So this is really, again, a comprehensive plan that includes not only creating a trust document, but also ferreting out the different kinds of assets and the tax considerations and review of the different probate, the savings opportunities as well. So we're doing all of this as a comprehensive plan, not just creating a document that we have you sign and kind of send you off on your way. So we do everything on a flat fee basis. We'll really look at what it is that we are going to be doing in each particular situation. And we always tell clients before we start moving forward with what we're about to do, exactly what the cost will be. And then we'll have client agree that that makes sense for them. And they'll give us the go ahead. And then we'll start based on mutual knowledge of exactly what the cost is going to be. So that way, in my perspective, they can feel comfortable coming to us with questions and ability to kind of review what we're doing for them and understand what the cost will be without feeling like, I can't call because it's going to cost an additional amount, or I can't, send an email because it's going to cost an additional amount. You'll know ahead of time. We're pretty good at being able to ascertain what the cost will be from our time perspective because we do this so frequently. Pretty common range is $8,000 to $12,000 as a total for the Medicaid asset protection planning. Now, that doesn't necessarily include all of the other planning that could be necessary, like wills and revocable trusts and powers of attorney and living wills that would be outside of this particular planning component. So if those things are added on top, the fees could be more significant than what you're seeing here. It's a time-consuming process, and there's a lot that goes into it. There's a lot of nuance, but invariably, we feel that we provide a benefit even if the long-term care never becomes necessary and you didn't need to save the assets from that kind of spending. The probate savings and the Pennsylvania inheritance tax savings will be more than what the cost for doing this planning will be. And it provides you with the peace of mind that the assets will be protected from the long-term care expenditures, also protected from the things that might happen in the children's and beneficiaries' lives while the assets are in the trust. Okay.
Okay, we have come to the question and answer portion of the program. Thank you so much, Doug. Really great information. I know that it really was responsive to a lot of the questions that we get when we meet with clients. So let's see what folks have been asking, if things have been going on. So one of the questions is, why not simply gift assets to the community spouse? Can the community spouse be an income beneficiary of the trust?
So gifting the assets to the community spouse will not serve to protect the assets. What Medicaid looks at is the total assets of husband and wife. And so even if they are all owned in the community spouse's name, they will still say, what is the aggregate value of these assets? And those assets will all be an available resource to spend down, and we'll still have that same calculation as to what the community spouse can retain. They'll be able to keep the car, they'll be able to keep the house, they'll be able to keep one half of the financial assets, or the $137,000, whichever is less, and they'll also be able to keep their own IRA. Everything over that would still have to be spent down mechanically until the money is gone.
Okay. Lots of other good questions, some of which we answered throughout the course of the program. Question a lot of clients ask, and I see here, is if the home is in an irrevocable trust, who pays the bills?
So that's a good question. So it depends on what you're speaking of as far as the bills. I think you're probably asking for the home.
Utilities, taxes, etc.
Gotcha. Depends on whether we write it to be a life estate or a long-term lease. So for the life estate agreement, part of the retention of the right to live in, use, and enjoy the property will also be the requirement that the grantor, the client at home, will be paying the expenses for the upkeep and maintenance of the property. So life estate agreement results in the clients, the grantors, continuing to pay all of the expenses. Long-term lease would result in the trust being responsible to pay those expenses. So again, the grantor pays a rental payment to the trust, trustee deposits that money into the trust account, and then the trustee pays all of the bills using that rental amount on a monthly or annual basis. Also, sorry, Annalise, I just want to go back. I think I neglected one component of that first question. I think there was a question as to whether the spouse at home can keep an income flow from the trust. So the answer to that is you could retain a income flow from the irrevocable trust. It's just that that income flow will be considered an asset of the person who goes to the care facility. And so what you would end up having potentially is that income just simply come out of the trust and then have to be paid to the nursing home anyway. And in those cases where we have a community spouse, other thing that you have to remember too is that that community spouse at some point in the future could become an institutional spouse themselves. They could have to move to a care facility themselves. So if they have retained an income flow, that income flow would always follow them. And if they move to a care facility, whatever that income flow is would go to the care facility on a monthly basis and have to go toward their care. So what we usually prefer to do, rather than reserving the income flow, is accumulate the income inside of the trust and allow for the clients to keep a chunk of money in their personal name from which they'll spend for necessities over time. And then if they ever need money back, we've built in the ability for the kids to transfer and gift assets to them. So we'd rather do that than have this mandatory payment come out of the trust, because that mandatory payment will basically be lost to the nursing care setting in one way or another if one or both of the spouses need care.
Excellent. Thanks, Doug. A lot of questions about trustees. One specifically, if you have multiple children, are they able to act as co-trustees?
So that's a good question. And we have clients that go over this with us all the time. Selection of trustee is, of course, a paramount issue. So the short answer is yes, you can have co-trustees. So if you really want that, that is an option. You just have to consider the logistics. So the plus is that you get a check and balance, you get multiple kids involved. The downside of that is if you ever have a disagreement between the trustees, you could have some paralysis and things maybe can't get accomplished that you would want to have done more quickly and easily. You could also have neglect from one of the trustees, and then the other trustee can't get things done because their co-trustee isn't responsive. And then there's obviously just the natural logistics of having multiple trustees, maybe in various locations. They would each have to be at different places at the same time. So they would have to coordinate schedules and be together to do a lot of things. So just have to be careful. You can have co-trustees. If I had to say, do I have a preference? I like the scenarios where we have a single trustee. I just feel like it moves more quickly and easily, and there's a nice flow, and there's not a lot of the matching of schedules and coordination and things like that. That being said, if a client is particularly desirous of having co-trustees, we can certainly create that document that way.
What if someone who's been named as trustee sort of goes rogue and goes off the rails and is not doing what they're supposed to be doing? Is there a mechanism by which that person can be removed?
So the answer to that is yes. And the most common mechanism for that would be, well, there are two different trustees. One will be the family trustee, and then there's the disinterested distribution trustee that we had talked about to create that additional asset protection. So for the distribution trustee, we usually give the family trustee the ability to fire them and remove them. For the family trustee, many of our clients appoint someone. Again, we refer to that person as the trust protector. And the trust protector has the ability to periodically remove and replace not only the distribution trustee, but also the family trustee, in case you ever have that scenario where son or the daughter or loved one, again, goes rogue, isn't doing what they're supposed to be doing, and we need to remove them. We haven't had to do that yet, but it is something that we account for and plan for. Now, the trust protector, clients will probably ask, well, who can act as a trust protector? Frequently, we fill that role for clients. Trust protector has a lot of responsibilities or options to provide benefit for the kids and the family. And the trust protector basically is someone that you empower to do things that ordinarily would require court approval. As an example, the ability to update terms of the trust if there's a law change or if there's a family life change, remove and replace trustees, also the ability to change location or jurisdiction of the trust if that ever became necessary, the ability to insert certain tax clauses that might be advantageous for the family over the long term. And, we tend to be a fairly natural fit for this because we just are conversant in all of these issues and an easy resource for clients and their families. If they come to us as trust protector, then, we're able to help quickly and easily. That being said, you could name any non-immediate family member, so extended family, friends, disinterested parties, preferably, to fill that trust protector role. The trust protector is a non-fiduciary role. So it basically is not something that the trust protector has to monitor on a daily basis. They're not involved in decisions on a regular basis. They only step in and come into play when asked to do so. And it's very common for the trust protector to never have to do anything. And the family just takes care of their business as trustees and beneficiaries and grantors and all that kind of stuff without the trust protector getting involved. Trust protector is there as a last resort in these scenarios that ordinarily would require court approval. And you can feel comfortable that you've got somebody who's lined up to take care of things more quickly and easily. There's no ongoing fee or expense for a trust protector. It's basically as called upon. And the most common scenario would be for a trust protector to maybe charge something on an hourly basis when called upon, or even on a flat fee basis if it's more like an ascertainable action and activity.
Thanks, Doug. We have so many questions, folks. Thank you so much for being so engaged. We won't be able to get to all of them. I think we have time probably for about 2 more. So one of them is, what about folks that have 3 million plus in assets? Does this planning still make sense for them?
So it's a good question. I mean, the thing that you have to be cognizant of is that in order for you to really get significant benefit out of the Medicaid protection part of the planning. So you can do this planning and you'll still get benefit. You'll still get the inheritance tax savings. You'll still get the probate avoidance, which are great. But if you keep a chunk of assets in your name that basically would be sufficient to pay for 5 years or more if you need nursing home care. So let's just say you have $3.5 million and you keep $1 million and you put $2.5 million into this irrevocable trust. Well, even if you get through 5 years, and if you still have $1 million in your name and then need nursing home care, that $1 million that you had retained will be more than 5 years worth of cost in a nursing home care facility. So you'd have to spend through that money anyway to get through to qualify for Medicaid. So I think my answer really is, it's still valid planning, but in order to really get what you're looking to achieve, you'd have to transfer all the way down to basically like $500,000 or less in order to really have it make sense. So the reason I grapple with whether it makes sense or not is I often think to myself, like, will somebody who has $3.5 million really want to transfer 3 million of that into the Medicaid Asset Protection Trust so that they only have $500,000 or less in their personal name? I've yet to have a client who has decided that that made sense for them. Doesn't mean it can't be done. It's just that that's really what the hurdle is. Are you going to want to gift that much to have it make sense?
Okay. And I think probably our final question here is, what about mortgages? And so the specific question is, does it make sense to use IRAs to pay off mortgages? And certainly you can discuss transferring homes with mortgages to irrevocable trusts, et cetera.
So if you have an encumbered home, so if you have in this scenario that was just discussed in the question, you have a client who has a house, but they have a mortgage and they're making a mortgage payment every month on it. And maybe their main financial asset is their IRA. And they have enough money in their IRA to pay off the mortgage. If they want to transfer their home into the Medicaid Asset Protection Trust, they would have to pay off their mortgage in order to do so. It would be a violation of the terms of their mortgage to transfer ownership of the house. And so they would potentially have that mortgage called by the mortgage company. And so most clients will pay their mortgage off before they transfer it into the trust. Question here is, do they use their IRA dollars to pay the mortgage off in order to transfer the house into the trust? This is, again, not a question that we can give a perfect answer to, yes or no. It depends. It really depends on what you value and what you think is most important in your worldview, and also what your financial advisor and your accountant is telling you will be the impact of doing so. Because if it's a traditional IRA and you're taking a big chunk of money out of it in one particular year, that means you will have an extra however many $100,000 potentially of income in that year, and that's going to push you up in the income tax brackets. So you're going to have to pay a chunk of that to the tax man, and then the balance can go toward paying off the mortgage. You know, it may be the right thing to do, but again, it will also partially revolve around whether you ultimately need nursing home care. So none of us can really answer whether that's going to be the case or not. And so you're really making a judgment call. Do I sort of take this tax penalty up front in order to get the long-term asset protection for the house and you know, whatever the value of those dollars that go into it would be?
Thank you, Doug. All right, folks, that is the end of question and answers. Sorry about that. There are a ton of unanswered questions, and we'll do our best to work through those and get in touch with you. And there is an excellent benefit for those of you who joined us today for it's a VIP discount. If you get in touch with us and schedule a consultation before the end of the year, you will get a $500 credit towards your planning. So you can reach out to us at our office number that I am including here. That is the end of the presentation, so just give us a call. Like I said, we'll try and work through those questions and get in touch with you guys. Certainly, if you call and schedule a consultation, we'll go over the specific details of your planning during that meeting. I do see that there are a number of questions here about unique situations to you individually and your family. So we can definitely talk about that. And we'll look forward to hopefully seeing all of you soon. I saw lots of familiar names on our attendee list and a lot of folks that I haven't met before. So welcome to you folks, and we hope to see our existing clients again soon. And thank you, Doug. You did a fantastic job. I hope you all enjoyed the presentation. Take care.
Thanks so much. Great to have you guys with us.